Hello everyone. So in this session we will be discussing the GS-2 mains 2025 paper in detail bit by bit. Yes, this year's GS-2 paper was a bit different, we can say relatively not that easy as compared to previous years. This is how UPSC frames the papers. One of the paper or two of the paper of the GS will be difficult or different. So, even if it is difficult, it does not matter, because we all know the exam is relative, that is how better you will score as compared to your competitors, that will make the difference. Also, many of the questions had an anchorage around current affairs. Obviously, IR will have an current affairs connotation, but polity questions also had a we can say the roots in current affairs. They may appear to be traditional questions, but if you write those current aspects as well, you can score well. They do not directly ask current affairs, but they have an anchorage, so you have to incorporate that. That will make the difference in your answers. Okay, we all know GS2 consists of 4 parts: the syllabus, polity, social justice, governance, and IR, polity, governance, social justice, and IR, and the paper was heavily tilted towards polity. There were as much as 10 questions on polity, 3 questions on governance, 3 questions on social justice and of course 4 questions on IR. So, more than 50% of your paper was polity and governance, and yes, it may feel like they are very core questions, but most of the questions, more than 60-70% of the polity and governance questions had their seeds in the current affairs, the contemporary events. Okay. So, let us discuss each question bit by bit in detail. So, first question itself from the Representation of People's Act. So, the question talks about discuss the corrupt practices for the purpose of the Representation of People's Act. First part. Yes, first step of answering the question should be breaking the question, identifying the various parts and plucking those parts and writing accordingly. So that you cover the entire meet the demand of the question and write in a 360-degree manner. So, discuss the corrupt practices for the purpose of Representation of People Act. First part, analyze whether increase in assets of legislature and their associates disproportionate to their known source of income would constitute undue influence and consequently a corrupt practice. So, basically it talks about Representation of People's Act 1951, asks you to define what is the corrupt practices in the Representation of People Act. So, corrupt practice, and second part it is saying that whether undue influence, whether increase in disproportionate assets is equal to undue influence in the elections and thereby a corrupt practice. So, basically this is what the question is demanding. Okay. So, write in the introduction that you can write in the introduction that Representation of People Act 1951 deals with the actual conduct of elections, and to keep the elections free and fair and transparent, there there exists a provision in the Representation of People Act, section 123, which deals with the corrupt practices. Even if you do not know section 123, do not write, at least write corrupt practices. Even if you have not read in detail about the corrupt practices, at least guess about it. Corrupt practices will be what? Of course, in our Indian elections, lot of money and muscle power. So, bribery, bribery is one corrupt practices, giving money in cash, giving cash or kind to favor, to get votes for himself or herself. And then comes also use of polarization, that is asking votes on grounds of religion, caste, language, that is polarizing the electorate. Then use of personal vehicle, for voters to cast vote, that is you use your vehicle, that that vehicle will you find some voters, okay, sit in this vehicle, we are taking you to the polling booth, that is a corrupt practice. Then you can write that also, spending beyond the limits, as mandated by the Election Commission of India. Certain limits are there, that much money only you should be spending in election. If you spend more than that, that would constitute a corrupt practice. Misuse of government machinery, that is in the Indira Gandhi, former Prime Minister, was disqualified, as she in the Raj Narayan case, judiciary disqualified her from being elected, as she was accused of using the government machinery to garner votes for her, especially office of district collector was seen campaigning for her. So yes, these are all the corrupt practices, and of course there is undue influence is also one such corrupt practices. And if the election commission sense that corrupt practices have been used, they can disqualify the candidate or even cancel the election, as it did in 2017 in the RK Nagar by-poll in Tamil Nadu. Bribery was happening to voters, the election commission cancelled that by-poll. So in corrupt practices, it cancelled that. So, and then you can write the connector after this, that undue influence is also one of the provisions in the section 123, where the voters are threatened, coerced, that is kind of undue influence. You threat them, coerce them, that you vote for in a particular manner, that would also constitute a corrupt practice, and that will lead to disqualification. So then you come to the second part, here you write the connector about undue influence, analyze whether disproportionate okay, will constitute, whether now you have to analyze here in the second part whether disproportionate assets increases of a legislator, that will lead to an undue influence and thereby corrupt practice. So you write there has been reports by ADR that once elected as a parliamentarian or legislator, even before elected, there is increased disproportionate assets of the legislator. ADR puts out that people who got re-elected in the 18th Lok Sabha from the 17th Lok Sabha, around 50% of their income has increased, maybe white money, but black money also, they will use shell company, etc. And it also mandates that you file an affidavit that show what is your income, the Lok Prahari case. So there are already some checks and balances are there to check the disproportionate assets, whether they have been increased or no. and they even disproportionate assets are also dealt with various this Prevention of Corruption Act. Even ED, CBI also looks into this, the disproportionate assets of the legislators, but the question asks whether there is a relation between them. So, analyze, there are two variables and you have to analyze. So, you can make this table, disproportionate assets increase, undue influence, this can be the relations, and you write corrupt practice, So, in a tabular format you can give more information. So, disproportionate asset, no undue influence, so not a corrupt practice. If disproportionate asset has increased, but that money has not been used to influence unduly in the election, so not a corrupt practice. Then you can also write disproportionate assets, known sources of income increase, but still that person does not use that disproportionate asset in elections, maybe he exits from the political life, that also can be a case. So, no corrupt practice, but here disproportionate asset, yes, undue influence, and yes, it is corrupt practices. So, this is the relationship you explain or you just show in this in tabular format. So, disproportionate asset increase does not necessarily mean that it will lead to an undue influence in the elections, thereby not a corrupt practice. If it is proven that it has been used, then it will be a corrupt practice. So, this way you write, isn't it? A simpler manner you can explain, though it has been found that though does not necessarily there is a direct relationship between this and this, but various analysis by ADR etc. can highlight that indirectly, even if even how the electoral bonds case happened, and Supreme Court there remarked that it was a way to bring black money in the elections. So, without disproportionate asset increase also, that way you generate a black money, use CBI, ED etc. to get donations, electoral bonds, and then that you influence the people in the elections, if the Supreme Court had remarked that. So, even the electoral bonds was kind of bypassing this, no, no undue influence, but disproportionate but undue influence. That way it took and etc. That way also in elections it was influence. Further, even if there is no direct relationship, but there can be a correlation can also be found. So, what is that correlation? See, correlation between them. See, in our politics there has been increasing criminalization of politics, we all know. Criminalization of politics is happening. So, this you can make this graph. Now, this is 18th Lok Sabha, 17th Lok Sabha and 16th Lok Sabha. As per ADR, how many were from the criminal background here? 30%, then here 33% and 43%. So, as criminalization of politics is increasing, this is criminalization of politics. And also ADR has found that number of crorpatis have also increased. So, crorpatis they were 83% in 16th, it became 88% in 17th, and 93% are crorpatis. So, even if there is no direct relation, see, this also increases and this also increases. So, there is an implicit correlation as well. So, even if there is no direct relationship between corrupt practices and disproportionate assets, but see, this data is pointing some correlation. So, we can say you can write other way, this side you write this, though there has though doesn't necessarily mean that they have a direct relationship, but some correlation can be found, that even this is croropatis maybe from legitimate sources, but but yes, there is no direct, but there is an indirect relationship between them. So, in the conclusion you can write, yes, election forms the foundation, free and fair election forms the foundation of democracy. The election commission should also look into in very very deeper manner whether even the legitimate sources of money can be used to garner undue influence on the electorate, and thereby leading to corruption in the free and fair happening of elections. This way you can write, yes, but the main thing was in this question was showing this relationship, disproportionate asset, undue influence and corrupt practice. This don't miss out on this. So, this way you can write this answer. Yes, lot of things were in news especially during the electoral bonds case. Many articles had come about the corruption in elections, etc. So, you can have that anchorage was around that issue. Okay. So, let us move to the second question. Administrative tribunals, yes, but problem would have been this reforms rationalization made in 2021. Yes, recent means contemporary issue, and also this was an impactful reform. So, 2021 will become a part of your core aspects. Okay, so this is you have to study when you are studying tribunals that similar tribunals were merged, etc. So, let us discuss this question. So, we can say this is not out of the box, this is part of your core now. Certain reforms happen which happen after a long time, so that become part of your core syllabus, not current affairs. Okay, and this is that part. So, yes, first step will be breaking the question, comment on the need of administrative tribunals as compared to the court system. So, need, assess the impact of recent tribunal reforms through rationalization of tribunals made in 2025. The key here is you have to assess the impact. You don't have to write just what were the reforms. It is clearly saying assess the impact. So, what impact did it create after that? Okay. So, 2021 today, 2025, and also it is coming to an end 2025. So, 4 years are enough to assess the impact, what happened after that. Okay. So, first part I guess not much problem must be here. So, introduction you can write what are administrative tribunals. Administrative tribunals are quasi judicial bodies. They represent, they don't have the they are not of totally judicial nature, neither totally executive body, they are a mix of both. So, that is why they are quasi judicial bodies. In India, article 323A talks about administrative tribunals. Okay. So, that can be an intro, and the administrative tribunals were inserted in the constitution of 42nd Amendment Act because the need arrived because of the following reasons. So, you write first, administrative tribunal provides speedy justice as compared to the court system. CAT has to Central Administrative Tribunal has to give its verdict within 90 days. Speedy justice, timely justice as compared to the court system. Courts have lot of pending cases, around 5 crore pending cases are there. So, tribunals more of a specialized nature, more specialized, etc. Nature of the work is dealt by tribunals, which the judiciary may not have specialization, especially the technical aspects, service related aspects. Now, the new technologies are coming, AI, etc. There too you will need tribunals in the future. So, those aspects, judiciary is more, judges are more well versed with the law. So first if they keep on hearing all these specialized matters, first they need a lawyer, then the lawyer will take a lot of time to explaining this, then they will give a judgment. But if you have the expertise in this all, so make tribunals. So that was the need, speedy justice, timely justice, and to also reduce the burden of the judiciary, of the traditional conventional judiciary. Judiciary is already overburdened, or approximate 4.93 crore, approximate 5 crore cases are pending with the judiciary, around 88-90,000 with the Supreme Court and rest with the lower courts. So that's why there was a need as compared to the this court system. So first half you have explained. So next need of what are the impact. So in 1 or 2 line write what was the need for these reforms, why reforms of tribunal they were brought in. So you can write there these reforms were brought in because there was tribunalization of justice. That is tribunalization of justice means there were a lot of tribunals were created, more than 50 tribunals. An incident happens, you create a tribunal. So it happened, tribunalization of justice. And also there were a lot of pending cases with tribunals itself. CAT today has, Central Administrative Tribunal has around 1.2 lakh pending cases, and it was supposed to give judgments within 90 days, and now it has 1.28 lakh tribunals. Some incident happened and they create a tribunal, that led to tribunalization of justice. Even some tribunals like FCAT, that is Film Certificate Appellate Tribunal, hardly heard of 1 or 2 cases in a year, and you have to then create such a big infrastructure. At least one tribunal means you have minimum 10 to 15 employees, a judge, then their residence, cars, etc. So lot of economic waste also, infrastructure waste, and that tribunal heard 1 or 2 cases in a year, and what the whole time the judges will keep on doing. So that's why there was a need for reforms in the tribunal, and accordingly this act was brought in. A tribunal reform rationalization was made in 2021. What that act did is that it merged similar tribunals together. It merged also some tribunals were their jurisdiction, some tribunals were abolished and their work was transferred to the requisite high courts, like the FCAT was abolished. And also after the, also you can also open up that L. Chandra Kumar case, that after the L. Chandra Kumar case, the appeals with the of the tribunal laid with the high court. So you in ABS will go to the high court. So what was the need of the tribunals? So tribunal rationalization happened, and tribunals were rationalized, and also uniform criteria was brought in with this act. 4 years you can be part of the tribunal, and minimum age should be 50 years, and the search cum selection committee will search the appropriate members, but there is a dominance of the executive. So this was the reforms brought in. Now the impact. All right, some positives. It abolished the tribunals like FCAT, which heard very few cases in a year. It streamlined infrastructure, streamlined the economic side of the tribunals as well, that is minimize the wastage, infrastructure use, etc. And also since many tribunals were there, some tribunals appeal, many cases were appealed to the high court, so that didn't make sense to have a tribunal. So those tribunals were brought in under the separate division in the high court itself. So that is a positive impact. And you can write then again, yes, those aspects you can write. And the negative impact is what? Many negative impacts. It leads to more of centralization, that before there were tribunals at various places, now you have to go to the high courts. Some tribunals were shifted to the high courts. The second, now tribunals were created for specialized, because they are specialized, and then again you are taking to the high courts, so they lack of expertise there also. So and further whether the number of cases have decreased. If you shift the tribunals to the courts, then obviously the courts get overburdened, and there is a substantial increase in the number of cases with the high courts since 2021. We will look at the data of the National Judicial Grid. See here, hopefully we have it. Okay, here, see this, see in 2021 how many cases were pending with the, see yes, this is pending dashboard of high courts. 2021 there were around 24 lakh pending cases when this tribunalization reform happened, approximate 24 lakh, and now you see in 2025 69 lakh. There's such a sharp increase in the number of cases with the high courts, so more high courts get even more burdened. Hope it's visible now. See 2021 24 lakh, and now here 69 lakh, approximate 70 lakh cases. Isn't this a sharp increase after the tribunalization reform? The courts get more overburdened. So this is more of a negative impact. And see, it was more of a, there was not a sharp increase before. Before, see, 2014 almost a minor increase was there, 2014 etc. But here, from here you see how is the sharp increase. So yes, tribunalization of justice, then you burden the high courts. Also yes, before this act, ordinance was promulgated, and that ordinance was struck down by the Supreme Court, citing that they are having a tenure of 4 years only. They should have 5 years and minimum age of 50. So they need a younger expertise also. So, but that act incorporate all this. So in the future, if it's struck down, then the impact will be totally negative of the Reforms Act. So that way you can write the impact, but yes, rather the tribunals should have independence also, as they deal with quasi-judicial bodies. So there can be a National Tribunal Commission which will assess the impact of the tribunals and make recommendations from time to time, and also can have a powers to select the members of the tribunal as well. See, new technologies are now coming, AI, artificial intelligence, crypto, etc. There too a new need of more tribunals will come. So rather than creating tribunals in a reactionary manner, you make some impact assessment and then create tribunals. That work can be done by the National Tribunal Commission. So this way you can conclude, yes, this all aspects you have to write in this. One should not miss out that you have to assess the impact of the tribunals, not just write what were the reforms. Many people we interacted after the means, they wrote only the reforms, at least if some of them who remembered, but you should study as a part of the core aspects, this all, not current affairs. Okay. So this is how you can write. Compare the contrast powers of pardon in India, President's power pardon in India and the USA. Are there limits in the both countries, and what are the preemptive pardons? Okay. So yes, compare and contrast President power, pardon power in India and in USA. So this, are there limits in both the countries, and what are preemptive pardons? Yes, this is not from out of the box. Preemptive pardons were in news during the US elections. Okay, we will talk about it. From that they have asked. Okay, and yes, in some newspapers, in newspaper also there was this distinction was also given about the pardon powers of the Indian President and the USA President. So it's important to read newspapers. Okay, newspapers give current affairs in a story format. It is easier to remember in story format rather than mugging up. Yes, mugging up is required, but understanding which the newspaper will help, and then you remember things. That should be the approach. So compare and contrast the pardon. Okay, at least write some compare and contrast first. India, USA. So, write in the introduction the pardoning power is a power which removes the sentence of the convicted or to be convicted person. It's more of a power of the executive to remove any judicial errors. Okay, that is the pardoning power, and the both the world's largest democracy and the president of the world largest democracy and the world's largest and the world's oldest democracy president have the pardoning powers, and the and the differences between them are as follows. So, you write India. So, first you can write the similarities that both vests with the executive. They absolve the convicted person of their any any fallacy or any crime committed by that person, and it's more of a humanitarian ground. That can be the similarities. It's saying compare and contrast, then you write the differences, then it is based on article 72 of the Indian Constitution, here article 2 of the US Constitution. Then difference, it is to be exercised on the basis of aid and advice of the Council of Minister. This is his President's discretion, total separation of powers. Okay. Then the Indian President can pardon the person, on the crimes committed on the Union list of the Union laws, then court martial, and also state laws where the person has been sentenced to death. So, only when death sentence of the state laws, that can be pardoned by the Indian President, and the US President only the federal crimes, federal laws. Okay, and this can be the differences you can write. And yes, this Indian President pardon totally wipes the punishment etc. from the records as well, that the person was given so and so punishment and it was pardoned. But in the US, it remains in the record that person had committed such crime and the pardon was granted by the US President. So, yes, this is the differences. Then the question talks about, are there limits? Yes, write the limits of the both countries. This is also a limit only. Indian President pardon is not totally discretionary. The limit is based on the aid and advice. Indian President also cannot pardon the crimes committed under state law except on the when the person is sentenced to death. And then other limit, yes, this much only, and yes, it is subject to judicial review. Indian President pardons are subject to judicial review, and US there is no such limit exist. In the US limits you write the only federal crimes the US President can pardon, and next you can write the limit is that when impeachment is going on, the President cannot, US President cannot give pardons to that. So, these are the limits imposed on the US President. So, yes, then you come to the next part of the question. It talks about preemptive pardons. Yes, preemptive pardons are those pardons which are given before the conviction of the offence or before framing of the charges. That is preemptive pardons, and such pardons exist in the United States. It does not exist in the India. So, this preemptive pardon was in use when the former President of US, Joe Biden, gave a preemptive pardon to his son Hunter Biden in some drugs and sexual abuse cases. Then preemptive pardon was given and it was in news and also all over the social media. Your favorite Elon Musk was talking about it on social media. That is why you should also be not totally remain aloof from social media. I am not a big fan of aspirants remaining totally boycotted from social media. Okay. So that is preemptive pardon. And also one traditional example, that former US President Gerald Ford gave preemptive pardon to what was that Watergate scam, Eisenhower, yes, sorry, Richard Nixon. Yes, he gave preemptive pardon to Richard Nixon on Watergate scam. So this is preemptive pardon. So basically, then you can conclude that the pardoning power though has similarities but has differences as well, based on the type of democracy India, based differences because of the foundation of the democracy of both the countries. India's democracy is based on theory of separation of powers and checks and balances. So the pardoning power is subject to judicial review, checks and balances, but in US it's presidential democracy, so it's absolute discretion of the US president regarding the pardoning power, and there is not subject to judicial review as there is total separation of powers. So this is this question, yes, pretty much simple question. It was in news also, mentioned that Hunter Biden case, it will fetch you some more marks. It was in news also, lot of things. See, every year in the mains, things which are in news, specifically during December or November, December, January, November, December, January, February, these things which were in news have been asked in the mains. So 2024 December, November, December, and 25 January, February, things were in news that are asked in the mains of 2025. So similarly, whatever is news in will be news now will most likely be asked in the mains of 2026. This has been going on for a while. UPSC does this in previous years also, it has done this. So this phase is important for the mains of 2026. Okay, that's why UPSC demands an integrated preparation, not preparation in bits and pieces. Okay, so this is how you can write. Hope things are clear. Please bear with my voice. I am not keeping 100% well. Delhi's air pollution and our cough, watery eyes, etc., allergies. Okay, so let's move further. Yes, this was also in news because elections happened in the JNK after it was UT was formed, a union territory, in December, October, November itself in 2024. So they asked in the mains of 2025. So let's discuss the nature of the Jammu Kashmir Legislative Assembly after the reorganization of Act. Briefly describe the powers and functions of the Assembly of UT of Jammu Kashmir. Yes, elections happened into the Assembly and they framed a question. So right in the introduction, after the abrogation of Article 370, Jammu Kashmir was converted into a union territory. First time happened in India, a state was converted into a union territory with two UTs, Ladakh without an assembly, and Jammu Kashmir with an assembly, elected chief minister. So the this act deals with the JNK assembly. So you write then after that the features you write, the assembly will have a strength of 114, JNK assembly. At a strength of 114, 90 will be from the Jammu Kashmir and 24 will be from the Pak occupied Jammu Kashmir. So 24 seats will be reserved for them. So majority is 46, and of which of the 90, 47 will be for the Kashmir region. Seats are for the Kashmir region and 43 for the Jammu region. So this is what they are asking, and you can write elections were also held recently, and Omar Abdullah became the first chief minister of the JNK after the abrogation of Article 370. So, this you write in the middle part, then you come to this, describe the powers and functions of the UT, and you can also write Lieutenant Governor is the head of the executive head of the JNK Assembly, and Article 239A deals with the Jammu Kashmir Assembly. So, you write then the powers and functions. So, legislative A, legislative powers. So, what are the legislative powers? It can make law on the state subject except police and public order, which will be administered by the which comes under the central government, and on other subject it can make laws, etc. But Parliament will have an overriding power over it. So, that is the legislative powers of the JNK Assembly. Now, we write about the financial powers. Yes, it can prepare budget, etc. Money can be introduced with the with the permission of the Lieutenant Governor. So, except on the matters of the police and public order, that are the financial power. Executive powers you write, they can frame policy, etc. We will have elected chief minister frame policy. Then also the executive can be held accountable by means of questionnaire, etc. in the assembly of the JNK. So, this you write, but then add some current affairs as well. The 23rd Amendment Act increased the number of nominated members by the Lieutenant Governor by 3. So, previously there had 2 to be nominated and now 3 more. So, total 5 nominated members, and and these members are to be nominated by the Lieutenant Governor without the aid and advice of the Council of Ministers. So, it is absolute discretion of this Governor. So, this can create problem in the future of Lieutenant Government versus the CM, wherever there is UT. In Delhi that issue happened. Now in future in JNK it will happen, and this should be 2 should be women here, if not adequately represented in the assembly as per the opinion of the LG, and 3 2 will be Kashmiri migrants and 1 will be a person from Pak occupied Jammu Kashmir, and this 2 can be women also. So, this is how 5 it will be appointed. So, that will take the strength of the assembly, to from 90 plus 5. So, 90 plus 5, that will be strength of the assembly. So, 95. So, halfway majority is 48, right, 48, and this became the bone of contention when the elections were going on. If the some particular party gets a here, suppose this majority they get exact 46, and that then 5 people, those nominated people, can play a very vital role in bills, etc., and even bringing down the government as well. So, yes, in the near future this will be the confrontation between LG and the elected government, and also you can also include that in the conclusion that the central government has said in the Supreme Court that in the near future at appropriate time the assembly JNK's statehood will be restored. Even if statehood is restored, then this still the confrontation can be there between LG and the elected government because of this 5. In smaller states and smaller states and UTs, these 2-3 MLAs also play a very vital role because yes, smaller state 5 means a lot. It's almost 5% of the assembly, more than 5%. Okay, so this way you can write this answer. Let's move further. Attorney General of India, Attorney General, okay, no worries. Attorney General of India plays a crucial role in guiding the legal framework of the government and ensuring sound governance. So, Attorney General, yes, question has already come, but you have to break these parts of the question in guiding the legal framework and sound governance. Discuss his responsibilities, rights and limitations in this regard. So, you have to discuss his responsibilities, rights and limitations in this based on these two variables, guiding legal framework and sound governance. So, this way you can then cover the question in a holistic manner. So, right in the introduction, Article 76 talks about the Attorney General of India, who is the highest law officer of the country. He plays a crucial role in guiding the legal framework of the country, right? That he is the principal legal advisor to the government and ensuring sound governance, that is the policies of the government has been framed keeping in mind good governance aspects and are in consonance with the Constitution of the India, so that he can defend the government's policies based on sound governance in the courts. So, this way you can write in the middle part of your answer in this regard. His rights responsibility are as follows. So, you first write responsibilities. A, responsibilities. Yes, simple responsibilities you write from Lakshmikant that responsibility is to provide give advice to the government, the central government regarding the legal aspects to defend the government laws, etc. in the courts, so that they are not declared null and void, etc. Then you can further write about his rights. He has the right to audience in the courts throughout the country. He can sit in the parliament, be the part of a discussion, and also be part of committees as well without the right to vote. These are his rights. That is, in a way, he seeks to defend the government's policies in the parliament. That is from the sound governance perspective, as well as from the legal perspective. In the parliament, it won't be from the legal perspective. Legal perspective will be in the courts. In the parliament, he has to convince the opposition that those policies are for sound governance and not for violation of rights, etc. In the Aadhaar Act, you can say that the Attorney General was able to defend in the court to a certain extent. The Aadhaar Act stayed. Only some provisions of the Aadhaar Act which violated right to privacy were struck down, not the entire Aadhaar Act. So, it was, in a way, he was able to show that they were part of the sound governance and also from the legal perspective. So, that way governance, Aadhaar Act was for Aadhaar enabled payment system, Aadhaar biometrics for PM Jandhan, which is Jam Trinity, then Garib Kalyan Yojana. It was for sound governance, to plug the leakages. So, that way it showed it is his responsibility to show there for sound governance. So, that aspects you should also write, not just the legal aspects. And further it talks about limitations in this regard. Then you write limitations from the legal perspective, limitations from the sound governance as well. So, limitations, the legal perspective, no issue must be there, that he cannot defend a person accused of crime without the permission of the government of India. He cannot be head of a corporate entity, PSU, etc. without the permission of the government of India. These are the legal limitations, but also limitation on sound governance. Sound governance, what limitations are there? the advice is not binding. The Attorney General may be knowing that this won't stand in the court, but still the government doesn't heed to his advice, and then in the courts the act is struck down. Suppose the National Judicial Appointments Commission amendment that the Attorney General of that time may be of the view that it can't be defending the court, it's against the basic structure, but government may be adamant that we want to bring these reforms. So that is the limitation, the advice is not binding. So it affects sound governance. Further, there is no security of the tenure, you appoint anyone and remove any time. So that may also affect institutionalization of sound governance, that the Attorney General knows his existence is dependent on the whims and fancies of the government and may not be able to give independent advice that will promote sound governance. And also it does not also it may also lead to conflict of interest. It does not put a total bar on the Attorney General defending a person against the government. It says that only without the permission of the government. The government may give permission, so that will also create a conflict of interest, thereby affecting good governance as well. So this way you can write about this. So you can write in the conclusion certain reforms like providing security of tenure, etc. First, bring out transparency as well in the functioning and the appointment of the Attorney General. So in a way, it will also reduce the burden of the judiciary. If the advice of the Attorney General is giving advice to the Government of India in a fair and transparent manner, so that will also ensure that the government's decision are not taken to the courts. And we all know the government is the largest litigator in the Indian courts, resulting in high burden in the judiciary, and the acts of the government won't be challenged also if are framed from the sound governance, etc., all those aspects. So this reform you can write in the conclusion. So yes, then don't miss out on the sound governance aspect. Legal aspects everyone can write, it's holistically given in Lakshmikant, but sound governance, that may be missed. Or you can write also, if you have space, some of the Attorney General, their present Attorney General is Venkatramani, and people who ensure legal as well as sound governance like Soli Sorabji, Stella Ward, etc., you can write. Okay, so that way you write, and then these aspects if you incorporate, that will make certain difference in your answer from your competitors. Okay, let's move further. Yes, governance questions, women's social capital, complements in advancing. Women's social capital, complements in advancing empowerment and gender equity. So you have to show complements. Okay, and what is women's social capital? See, women's social capital is basically women coming together, forming a network, building a relationship, and that relationship is based on trust. That is women's social capital, and self-help group is one of the most effective medium in India to build women's social capital. So that you write in the introduction, what is women's social capital? Basically it's about building trust, building networks between relationships that will coming together and empowering each other. That is women's social capital. So you write that into introduction, but you have to show that how it complements in advancing women empowerment and gender equity. So there has been traditional way of some of the traditional measures of ensuring women empowerment and gender equity, like gender budgeting, women specific schemes having women component. That is more of a top down approach for women empowerment and gender equity. Then you can write those some schemes having women component, that is right, Startup India, Stand Up India, it has 30% for some provisions for women, or women specific schemes like Matruta Vandana Yojana, maternity benefit program, you can write those aspects, and gender budgeting also, which is incorporated in a budget. So that is more of a traditional way of empowerment and gender equity. And you can show that that these all aspects does not necessarily lead to gender empowerment, as in India. You can see the India gender gap index. India ranks very low, around 131 out of 148 gender gap index. 131 out of 148. So to complement this, there is need for women's social capital, and India women self-help group have been highly successful in in socio-economic and political transformation of the women agency. Be it write some successful self-help group like Kudumshri in Kerala, or Looms of Ladakh, or Ajivika Bihar. So these have now connect with the social, economic, political transformation, how it led to gender equity, gender empowerment. It also had a cohesive relationship with the gram panchayats as well, and how women became entrepreneurs. Loom, especially, it talks about the luxury. It is about luxury woolen wear of Ladakh. Few self-help group were found by the divisional commissioner. He integrated them in the mainstream, and Loom became successful. And this way, even the government of India has many policies which seeks to integrate them with the mainstream, that is to advance for women empowerment and equity, that the self-help group bank linkage program, National Rural Livelihood Mission, Ajivika program now. So this way it tries to complement and supplement women empowerment, because top-down empowerment may not be always be successful. We can see how the 73rd and 74th amendment gave a provision for minimum 33% reservation for women, but there is Pradhanpati syndrome there. So we need women's social capital, and so that reason, even with respect to the 73rd, 74th amendment, the Pradhanpati syndrome, the Sushil Kumar committee had made recommendation of women federation, that is generating women's social capital, elected women representatives coming together, together they form a federation, you exchange ideas, build those networks, build trust, that will empower them more. And then also it talks about that how the elected member of parliament and member of legislative assembly who are women will act as a mentor to the women elected representatives of the gram panchayat and urban local bodies. That is basically generating women's social capital. In a way, it seeks to empower women through building their capabilities as the capability approach of Amartya Sen. So this way you can conclude. So women are politically, economically, socially empowered. This is all the question what it talks about. You can write this way. So e-governance, e-governance project have a built-in bias towards technology and back-end integration rather than user-centric designs. So basically, e-governance, they are saying, is more focused on technology and back-end integration rather than user-centric design. Basically, this is what the question is asking, and it is showing examine. So they are saying that e-governance is more of you integrate various departments, etc., and that is what is e-governance rather than focusing on the end user. So what is this? This is e-government. So basically they are saying that whatever initiatives of e-governance they take is more of e-government rather than e-governance. So in simple words, they are saying that e-governance is looked as an e-government, not e-governance. So this is in a simplistic sense what the question is asking. So hopefully you know the difference between e-government and e-governance. In a way it is asking this. E-government is what? Getting government online, that is e-government. Integrate back-end integration and you digitize everything, make a website, that is e-government, and digitize all the communication across the government departments, that is e-government. But e-governance is use of ICT tools for collective decision making, where there is top down and bottom up flow of information decisions through electronic mediums, that is e-governance. So this is the question is asking, it is more of e-government rather than e-governance. Yes, now it's simple to write. So write in the introduction, e-governance is about ICT, use of ICT tools for collective policy decision, collective decision making or management of resources, where the end consumer participates in the governance process, doing things together through use of ICT tools, information communication technology tools. But e-governance is often viewed as getting government online, that is e-government, getting government online, integrating various departments, digitize flow of communication from top down and across various departments. Suppose Ministry of External Affairs communicating with Ministry of Home through electronic medium, digitized medium, that is e-government. But there is less emphasis on the users, etc., because the policy is made by technocrats, by bureaucrats, without giving emphasis on the actual person, how it will be using it. For example, we have Aadhaar enabled payment system. You just come and you enroll. You cannot enroll yourself. You need Aadhaar facilitation center. That is more of e-government, right? E-governance will be you don't need to those facilitation centers. You don't need anyone to tell. You will enroll by yourself. And also there is Aadhaar enabled payment system. You need to take those machines to the people and tell them to do this. Then you will give their payment. That is, you need a middleman to take e-governance to the people. So it's more of a, because why? Because of lack of digital literacy, rural urban divide, lack of internet penetration. The interfaces not available in variety of language format, even speech. Some people cannot read. For there should be speech also in their requisite language they can understand. So it's more often this, not user centric design. Also many community centers were created as a part of the e-governance plan. They remain largely utilized. Electricity is not there. How then community centers will work? So this is you write, but in the end you write that these all aspects also have been incorporated in the Digital India initiative, where in regional languages, etc., the e-governance interfaces are available. There are also e-governance. There are also those helpers, etc., who educate the people. Also one side you can open up that, one side you get UPI, etc., to the people, but what about their security? So much cyber scams happen. You don't educate the people about the other aspects of digital payments, digital economy. Now digital arrest also happen. That is also less of e-governance, because people do not know that, people know that government has become online, that digital arrest also must be part of the government's governance process. So that is more of e-government, not e-governance. People should also be made literate about the other aspects of the digital India, etc. So because more focus on e-government rather than e-governance. So but in the end you write that it has also transformed in India. E-governance has also been more on user centricity emphasized, and it has transformed governance as well. And Aadhaar has been considered as one of the best model of service delivery, and even the Nobel laureate Paul Romer says that Aadhaar has transformed the service delivery in the country, and there is 80% increase in satisfaction among the people who are dependent on Aadhaar for their all those basic needs, that is the Pradhan Mantri Garib Kalyan Yojana, etc., those needs. So this way you can write in the end, because the question is saying examine. Okay. So one more governance question. Civil societies are often being perceived as being anti-state rather than non-state actors. Do you agree? Justify. So you should not be agreeing to this. If you understand the civil society, how they work exactly. So what is he saying? That the civil society organizations are often perceived as anti-state and are not non-state. This is the demand of the question, and it's asking whether you agree. Yes, simple question to write. Lot of things were in news also, FCRA, etc. So many people must have thought it's anti-state only. Right, civil society is the third sector of the government, judiciary, and civil society, which can be a unstructured organization like the people's movement, example the Kisan movement or the Anna Hazare movement, or it can be a structured organization in the form of NGO that work for the people, work for human rights, work for democracy, work for environmental issues, and often they work against the state. Against the state, there will be human rights violation, there will be environmental violation, there may be people may not be happy with certain policies, example the farmers protests, and so they are perceived as anti-state. How you must be knowing how in the during the farmers movement, how the farmers movement was labeled as anti-state and totally against the state. Some were even calling them as Khalistanis, etc. So why they are viewed as anti-state? Because they agitate against the state, they mobilize against the state policies, etc. They may not be happy, some people may not be happy with the state decisions. So that's why they are viewed as anti-states. You can write the Kisan movement, the Anna Hazare movement, all were fighting for something, but they are viewed as anti-states. Even Government of India report points out how some civil society NGOs were working against the state. The IB report had outlined that the protest by the environmental activists, organizations such as Greenpeace, Amnesty International, costed India 2 to 3% of the India's GDP. Yes, Greenpeace was there. It is now banned in India for FCRA violations. That they were doing protest at Kundakulam power project, and it was power project in collaboration with Russia. And there was reports that this is a US sponsored protest to stop the Kundakulam protest. So it was viewed as anti-state. But you should not be agreeing to this. You can write yes, civil society are not necessarily anti-state. They may be against the state, because for a larger cause, for democracy, for human rights, such as Rose Revolution, Velvet Revolution in Ukraine, etc. So those are not necessarily anti-state. They work for human rights, democracy, to bring larger reforms. Now this Ladakh protest happens, and the NGO of the Sonam Wangchuk is declared as illegal because for FCRA violations, Foreign Contribution Act violations. And so why all of a sudden? Because they perceive it as anti-state. But state should not view civil society as an anti-state, rather it should view as a non-state actors for the betterment of tomorrow. So also government works with many civil societies like Akshay Patra Foundation for midday meals, etc. MKSS, civil society movement brought in the improved governance by way of RTI Act. So civil society also works for better functioning of democracy, governance, etc. So rather it acts as a cushion between the state and the people. It acts as a shock absorber. When the state is doing some anti-democratic or violation of human rights, then there is civil society that is protects the people. Indian freedom movement was also a civil society movement only against the state. So it was anti-state. Yes, it was anti-state, but for the betterment of people. So these all aspects you write also, but in the end, right, the civil society too should have a bigger civil society, such as NGOs, etc. should have maintain transparency as well. They should there should be also a check on the vested interests through which civil societies, the vested interest where uses civil society to garner protests, etc. So this way you write a simple question. Incorporate examples, that is the main aspects of scoring well in NGO civil society type questions. Okay, we will take one more question on civil society, that NGO is there. Question 15, environmental pressure groups. See, civil society here, yes, pressure groups are also type of civil societies. What are environmental pressure groups? Discuss their role in raising awareness, influencing policies, advocating environmental protection in India. So basically 4 parts you have. First talks about you have to define what are environmental pressure groups. Then you have to discuss their role in context of awareness. Yes, influencing policies. And advocating environmental protection. So this is what the question is demanding. This is how you can structure. So write in the introduction what are environmental pressure groups. Environmental pressure groups are basically people's groups, people's movement which seeks to influence policy in the environmental realm. They can be informal movement by a people's movement, example the Chipko Andolan, or it can be more structured organization by way of non-governmental organizations, NGOs, which seeks to have an influence on the environmental policies. Example, Center of Science and Environment, the biggest environmental NGO in India, or Greenpeace, etc., one of the biggest world over NGO, Greenpeace. Okay, so this you can write in the introduction. In the introduction, you define the environmental pressure groups, and then you discuss their role, etc., bit by bit. So they play a very important role in generating awareness. That is, awareness can be generated by way of publishing reports, etc., about environment. Example, the Down to Earth magazine by Center of Science and Environment reports. You mobilize people, that is, some set of people are getting affected by certain project, environmental project may having an impact on the environment. Go to that people, talk them regarding this, or take they have some concerns, bring those concerns in the mainstream. That is how they generate awareness in the entire nation. Example, the Narmada Bachao Andolan, that way you generate awareness, or awareness nowadays through social media also. It's one awareness on social media, that is one. that is Save RA campaign was there, that is awareness on the social media, or international awareness, example on the issues of climate change, how the Greta Thunberg 5 days for future does. So that way they generate awareness. Then influencing policies by way of agitation, through PILs, through government representation to the government. That way they influence the policies. Agitation, lot of agitation happened in India with respect to environment. Narmada Bachao Andolan had an impact on the rehabilitation policies framed with respect to the environment or acquisition, which having an effect on the environment. So that way it has an impact, it influenced the policies. Then PIL, some environmental NGOs filed a PIL, public interest litigation, in the courts. Example, Center of Science of Environment had filed a PIL regarding Delhi air pollution way back in 2000. So the court directed that converted those diesel transport bus vehicle into CNG vehicles, and air pollution in Delhi that time came down. Delhi did not have such a chronic air pollution few years back. You go to 2002, that era. So this, that PIL, even MC Mehta case, Clean Ganga, PIL was filed. The case talked about give direction to clean the Ganges river. Even one high court gave a river status of a living entity. So that is also one way of influencing the policies. You protect that environment, and so this way they influence the policy, advocating to save environment through environmental education, etc. World Wildlife Fund, Wildlife Trust of India talks about protecting, advocating the saving the environment. Even Fridays for Future, Greta Thunberg talks about at international level to advocating for environmental protection. Even the NGOs, etc. have a representation in the UNFCCC. Even conference of parties happen there too, they keep on advocating about the environmental protection. So in the conclusion you can write, yes, for achieving sustainable development, etc., in under pressure groups plays an important role in balancing environment with development, also in connoissance with our DPSP, protection environment and wildlife, and it's also a fundamental duty. So that way you write all this. Yes, key is writing these three variables and giving examples. So that way you can answer the question in a very holistic manner and in an enriched content. See, Center of Science and Environment is a very big NGO in India. A lot of things they keep on doing. Sunita Narayan. Okay, keep an eye on the news regarding CSE. Also the firecracker ban, also it was some PIL was filed in the courts, and firecracker were banned in Delhi until recently. So this way you can write. Okay, let's take the next question. We will take the polity questions first. The IR question will take at the end. Question 11. Yes, constitutional morality, a very hot topic. They asked in the ethics paper also, and also in the GS-2, and they will keep on asking constitutional morality again and again and again and again. Okay. Constitutional morality is the fulcrum which acts as an essential check upon the high functionaries and citizens alike. In view of the above observation of the Supreme Court, explain the concept of constitutional morality and its application to ensure balance between judicial independence and judicial accountability. So basically you have to explain what is constitutional morality, and you have to show how constitutional morality can ensure judicial independence and judicial accountability. So, this is what the question is asking. This was a statement given by the Supreme Court in the Delhi NCT case, Delhi versus the Lieutenant Governor case in 2018 or 20 something, but that is not important where the statement is given. What is important? How you write this answer depending on this. So, basically the crux of this question is that it is saying that as we have separation of powers, and judiciary has time and again been criticized of being a very powerful judiciary in India, and like we said, how the former vice president also talks about judiciary acting as a super parliament. So, there is so much of independence of judiciary, and at the same time there are very few accountability mechanisms of the judiciary. What accountability mechanism we have? Only the impeachment process, that is also kind of useless also, you can say that, because the member committees held the judges. It's happened that the judges have done something wrong, but before they have been removed, the motion is set into work, they resign. So, this much of judicial independence there, and judicial accountability. What is the accountability? Also, judiciary has been mandated mandated responsibility in 3 key areas: as the guardian of the constitution, as the guarantor and protector of fundamental rights, and the highest court of appeal. So, what is the accountability with respect to those 3 aspects as well? Is there any mechanism to ensure the accountability of judiciary, and how the judiciary independence does not lead to a totally opaque system? There isn't, right? So, what mechanism can be to balance this? There is constitutional morality. Constitutional morality should balance this. So, this is what the question is actually saying. There is no proper checks and balances, external checks and balances on the judiciary. So, constitutional morality will act as a check and balance. So, this aspects you have to write. This way, now if you understand this all aspects, you can answer this question very easily. So, let us discuss now. So, constitutional morality, you write in the introduction, constitutional morality is about to whether the spirit of the constitution is followed or not. That is, it ensures that constitution is not just followed in letter but also in spirit. That is, all the constitutional values are also incorporated while taking any decisions of framing policies. That is constitutional morality. That is, justice, liberty, equality should be incorporated the constitutional values while framing policy or taking decisions, because the constitution is more of a in a structured format, and there are many ways to bypass the constitution that may go even, decisions may go even against the what were the intentions of the constitution makers. For example, the misuse of emergency. Though emergency was there in the is mentioned in the constitution, but the intention was not that you use emergency to suppress voices because your political power is going down. So, that was not the intention of the constitutional makers to insert emergency in the constitution. So, that is why constitutional morality is needed. Then this is constitutional morality. Follow the constitution in letter and spirit based on the what were the intent of the constitution maker was, what are the foundational values of the constitution, what are the constitutional values to be precise. That is, to what extent even the preamble can also act as a guiding light towards the constitutional morality. Without constitutional morality, it's more of a darkness, and constitutional morality acts as a north pole star in darkness. That is, when things are not clear that whether this provision is there in the constitution or not. That is, we all know we got the constitution in a very structured format, not the flesh was not properly filled, it was kept open because the constitutional makers wanted to give a constitution that will remain rigid, that is, it will remain flexible according to the changing times. So, that is not a misuse of the constitution. Constitutional morality will ensure there is no misuse of the constitution. Now, this you explain in the constitutional morality, then you write how what judicial independence and judicial accountability is more or less what we have discussed. See, Indian judiciary is one of the most independent judiciary, as it has the collegium system ensures that there is no role of not much role of the executive in its appointment. Also the removal process is also very is in the removal process of judges also the judiciary ensures its independence, because Chief Justice is also part of the committee and of the removal process, and the removal process is so tedious that no judge has been impeached for even if for any wrongdoing. Also there is security of tenure, and a convention is follows. The senior most judge is appointed as the Chief Justice of the country. So this independence is ensured, and the collegium system has been criticized for being opaque, etc. In that way, so that the independence of the judiciary does not result in opaqueness or judicial overreach, constitutional morality will ensure the limits on the judicial independence without compromising on the independence of the judiciary. So that is the role of the constitutional morality in ensuring judicial independence. Judicial independence can lead to judicial overreach also, judiciary usurping the power of the other two organs. Who will check on that? That check will be kept on by the constitutional morality. Now people say that judiciary has expanded its scope by way of basic structure doctrine, but basic structure is what? Reinterpretation of the constitutional values in the interpretation of the constitutional values in the constitution. That is, basic structure is the outcome of constitutional morality. It ensures independence and constitutional morality. So that way you have to write. And in accountability as well, there is no as such accountability mechanism of judges. Their own code of conduct, etc. they have. But if any wrongdoing, etc. happens, then which judges are been punished? A former CJI had allegations of sexual misconduct, and they formed a committee, and the CJI itself was the head of that committee. So then there was absence of constitutional morality within the judiciary itself. So that's why the accountability should be balanced with, can be ensured by constitutional morality itself. That is ensuring justice, liberty, equality within the judiciary itself. Then there is very high pendency of the cases is there. Then what about the accountability of that? That timely justice is also part of Article 21. So what about accountability of the judiciary? Then judiciary also has failed many times in protecting the fundamental rights of the citizens. You can write, if you want, the Umar Khalid case without trial. That is also judiciary accountability. Question mark on the judiciary's accountability. But who will make that accountability to judiciary? No one is above the Supreme Court. Above the Supreme Court is constitution, and constitutional morality should act as an accountability mechanism to that. So in a way you can balance judicial accountability and independence. So if an external agency is accountable, then judicial independence will get compromised. And that's why NJAC, National Judicial Appointments Commission, was struck down, because it encroached upon the judicial independence. So that way you have to write, but at the same time you should also write that some internal mechanism, etc. should be followed. Now there is less representation of women in the judiciary, and only one judge from the ST community till now, 3 judges from SC community. The absence of diversity of representation, accountability for that also. We have social justice also part of our constitution. Justice, social, economic and political. And constitutional morality should also be ensured by the judiciary in that aspect. Those aspects you have to write. Yes, if you understand this, all this, what the question is demanding, then it is easy to answer, not that tough questions. Okay. Let's move to the next question. Indian Constitution has conferred the amending powers to ordinary legislative institution with a few procedural hurdles. In view of this statement, examine the procedural and substantive limitations amending power of the parliament to change the constitution. A lot of things were in news with respect to this, changing the constitution, amendments, etc. Simple question to write, Lakshmikant, but incorporate some current contemporary issues as well, or okay. So I think not much problem. But try to give enriched content in such simple questions, because you have to differentiate your answer from rest to score that 1 or 2 extra mark. So right here, the Indian constitution is not as rigid as the US constitution and not as flexible as the UK. Yes, UK does not have a constitution. So the Indian constitution makers gave us this constitution, which is a blend of rigidity and flexibility. So flexible to make keep the constitution relevant according to the changing times. So the Article 368 talks about the amendment to the constitution, and the amendment can be made by through 3 ways: simple majority, special majority, special majority plus ratification by half of the states. So these are the 3 ways constitution can be amended: simple majority, special majority, and ratification by half of the states. Then yes, you write then whatever those, then you write procedure hurdles, etc. Write this in brief. Simple majority, like where simple majority half of the parliament, the example changing name of the state, etc. Special majority of the parliament plus 2/3 of the majority present and voting, and this special majority for federal features with ratification by the half of the states, example GS-2 amendment, etc. Then you write procedural limitations. That limitation is only parliament can initiate any amendment process, not the state legislature. Any minister, member of the parliament can bring the bill, and the limitations you write this special, etc. Modify that and write. And yes, and if yes, then you come to substantive limitation. Yes, substantive limitation is basic structure doctrine, that it will conform to the basic structure, that is secularism, rule of law, all those aspects you write. These are the limitations, and the other substantive, they are subject to judicial review, that the Supreme Court can struck down the amendment if he violates the constitution. Example, the National Judicial Appointments Commission bill was struck down, and here also you can give example half ratification, GST bill, etc. Special majority, Nari Shakti bill, so that you write. And even those amendments kept in the 9th schedule are part of the judicial review. So in that, those are the substantive limitation, basically constitutional morality. And you can, if you want, you write briefly the US Constitution amendment, how it is there, that even states there can initiate amendment, and there is constitutional convention also, constitutional assembly, etc. A bit complicated process in US to amend the constitution. If you want to write, and then in the end you write yes, constitution is a result of the freedom struggle movement, the ideals of the freedom fighters, which forms the basis of our foundation of our nation called India, that is Bharat. So constitution basically cannot be amended taking away the spirit of the constitution. In other cases you write, in the Minerva Mills case, etc., even the Supreme Court has outlined there should be balance between fundamental rights and DPSP. They cannot take fundamental rights in totality to implement some DPSP. Those cases Shankari Prasad, Golaknath, you can refer if you want. Simple question to write, not much problem here. Let's move further. Yes, again judiciary, discuss the evolution of the collegium system. 4 judges case you have to write. Critically examine the advantages and disadvantages, system of appointment of Supreme Court of India and at the US. So, first part, many parts, first part, second part, the advantage, disadvantage, and also you have to write something about the US, then only you can write about how US judges are appointed, then only you can write how you can critically examine advantage and disadvantage. That will give you a holistic completeness to your answer. So, yes, collegium system. The article, I start with article 124 and article 217 talks about the appointment of the judges to the Supreme Court and the High Court respectively. They are appointed by the President of India on the aid and advice of the Chief Justice of India. So, on the consultation of the Chief Justice of India, the collegium system was a result of the, you can say, judicial activism by the judiciary. So, it went through the 4 judges case. The first judges case, the SP Gupta case, the Supreme Court interpreted gave executive primacy over the appointment of judges when it said that consultation means concurrence. You consult the President, whatever President says, that is a concurrence, that is a binding opinion. In the first judge's case, the Chief Justice of India is consulted. Consultation does not mean concurrence. So, does not mean concurrence, that is primacy to the executive, not necessarily whatever Chief Justice of India says with respect to appointment, you are bound to appoint that. So, then that resulted in a second judge's case. Second judge's case was the Advocates and Record case, where the Supreme Court said that consultation means concurrence. Whatever the Chief Justice of India gives the opinion, that should be the final, that should be that person should be appointed. So, and also there should be Chief Justice of India should also consult with the 2 senior most judges of the Supreme Court. So, then presidential reference happened under K.R. Narayan, wanted some more clarification under article 143. So, in the third judge's case, the Supreme Court outlined consultation means concurrence, and also the Chief Justice should consult the 4 senior most judges before giving the opinion, and the plurality of the judges should be the decision should be based on plurality. That is, if even 2 judges give a dissenting opinion, the Chief Justice should not give the recommendation to the to the President. So, in a way, the Chief Justice became the first among the equals. Okay. So, this is, and therefore, judges case you write about NJAC. NJAC talks about National Judicial Appointments Commission, talk about a commission to appoint the judges, but it was struck down because it gave law minister a power. So, it violated the basic structure of the constitution, in compromise on the independence of judiciary, and it was struck down. So, these are the evolution of the 4 judges case. So, appointment happened as per the collegium system. They have their own internal processes, etc. Sometimes it depends on Chief Justice to Chief Justice. They publish the minutes of the meetings also on the website, but it is not an totally institutionalized process. Also, recent you can write how there was a dissenting opinion given by the one of the Supreme Court judge, female judge, about the appointments of the Justice Pancholi, and still the Chief Justice recommended its appointment because there were more senior people other than Justice Pancholi also. It did not take into his already some people were there from the Gujarat High Court, he was also from Gujarat High Court, so there was need for diversity also. Diversity is also looked into while appointing judges. Also very few female judges are there, only 11% judges are women. So why not woman was appointed? Also diversity was not there. Some issue was also there with Justice Pancholi in the past. So there was dissenting. Justice Nagarathan had given a dissenting opinion. Still Justice Pancholi is appointed. So this points to the disadvantage of the collegium system. Does not ensure diversity. Also it remains opaque. Uncle judges system is there. Nepotism is there in the judiciary. Even the Chief Justice of India, former CJI Chandrachud, talks about, yes, there exists nepotism. So these are the disadvantages, and advantages you write. It's independence of the judiciary. This collegium system evolved because of what? To ensure executive does not interfere with the judiciary, and it happened because Indira Gandhi appointed A. N. Ray, a junior judge, bypassing several senior judges as the Chief Justice of India, which affected the independence of judiciary. So it ensured independence of the judiciary. It ensures there is separation of powers. So that's why constitutional morality will act as a check on this. So this you write advantage and disadvantage. Then you come to the US, explain a bit USA appointment system. See, in USA there is an executive dominance, you can say, in the appointment of the judges. See, the president appoints the judges whoever he wishes, but that appointment has to be confirmed by the Senate. President appoints judges and Senate has to confirm that appointment. So Senate is, every state sends 2 senators to the Senate and they have to confirm by the so judges, suppose President Trump appoints Mr. X as a judge. So this has to be go to the Senate. The Senate will form a judicial appointments committee. Their committee will conduct interview of this person, whether that person is to be fit to be a judge or no. So the interview also is telecasted. It's not in camera, it's publicly. So that interview, etc. After that, the committee will circulate the recommendations. Some judges will recommend, some judges won't recommend, and this recommendation is circulated in the entire Senate. Then it is put to vote. If that person gets majority of the votes, then that person is elected as a judge in the US Supreme Court. So yes, this is both the organs are participate in the appointment of the judges here. And the judges in USA, there is no retirement age. You can remain judge till you die. Many judges have died in office as well, and also there is no such qualification needed to be a judge. Like in India, you should be advocate, etc. But there in judge you even a judge was appointed as young as 32 years of age, and even one judge did not had a high school degree. So this all judges have also been appointment. So advantage you write, it ensures that all 3 organs participate. There is no opaqueness in the judiciary, it remains transparent. Senate interviews are also published, recommendation is there. And negative side you write that politicization of the judiciary here. See, whoever controls the Senate will also control the judiciary. If the Republicans, Donald Trump is a Republican president, the Republicans control the Senate, so judiciary also they will control. So the Republicans are more conservative. Republicans are more conservative with respect to gun laws, abortion rights. So if those aspects go to the judiciary, and judiciary will give judgment with respect to the ideology of the Republican government. But is this the case? No. United States is United States. President Eisenhower was a Republican, appointed such a conservative judge to the Supreme Court, thinking that he will give conservative judgments. But when he went to Supreme Court, he became one of the most liberal judges, giving judgments on liberal lines. And President Eisenhower also said, I have made the biggest mistake of my life appointing this person as judge. So there also constitutional morality may be existing. So that is how the US Supreme Court works. So the positive negative also, it became a sort of convention that whenever the president is in the final years of its presidency, the Senate does not approve the appointments to the judiciary. Obama in his last year had recommended a judge to be appointed as a person as to be appointed as a judge of US Supreme Court, but that was not approved by the Senate because he was in the last final months of his presidency. So this is also one aspect. So yes, you can write in the conclusion the appointment process of both the democracies is rooted on the type of the democracies they are. In India, there is more of a judicial independence and non-interference of the executive and the legislature in the appointment process, whereas in the US judiciary, the Senate, all rest of the two organs also participate in the appointments of the judges. Okay, so this way you can write. Yes, these all aspects can be incorporated, which can help you fetch some more marks and give a more enriched overtone to your answers. Okay. So center-state relations, financial, lot of intergovernmental relations questions they ask in public administration. All paper 2 of public administration was full of center-state relations. They ask financial also, executive also, administrative also. Okay, and here also in GS-2 they ask financial relations, but you have to write in context of plant development. Okay, not only in terms of in the macro sense, but micro sense you have to write in terms of plant development. And first part is this evolving. So historical aspect they are asking, and how has recent reforms impacted the fiscal federalism. So two parts of the question. This is more of an historical part one, evolution of India's plant development and center-state relations, financial, and here you have to write about the contemporary aspects, recent reforms impacted fiscal federalism. So write in the introduction about the center-state relations that the center-state financial relations are dealt in the Constitution from Article 268 to Article 293. Okay. Article 268 to Article 293 deals with the center-state relations. So India is a quasi-federal state, and the financial relations, in terms of center-state financial relations, the polity is more tilted towards the center rather than the state, as major financial powers are with the central government, and the Finance Commission acts as a balancing wheel of fiscal federalism. And as per estimate, around for 60% of the financial needs, these states are dependent on the center. Only 40% of the resources required by the states are generated by themselves. Major of the major taxes, IT, income tax, corporate tax, are with the central government. So these aspects you can write in the brief in the introduction. So now you have to come to the plan development. So plan development means it talks about the evolution from Planning Commission since its inception to Niti Aayog today. So that is what it talks about. So to carry out plan development in India, India adopted a centralized planning, and for which it constituted a planning commission, which was which is chairman as the Prime Minister of India. So the planning commission deals with the allocation of resources, etc. to carry out centralized planning. It had also the financial powers of allocating resources. It formulated the fire plans, which were approved by the National Development Council and even approved by the Parliament, and based on this 5-year plans, the allocation was made by the central government, by the Planning Commission. Also the Planning Commission formulated with the centrally sponsored schemes as well and funded those centrally sponsored schemes. So till when there was right phase 1, when there was when there was uniform government, that is same party ruling at the center and at the state, the financial relations were not that frictious, but with the growth of the regional parties, etc., the financial relation in context of planned development become a point of friction between the center and state relations. The state governments accuse the Planning Commission in terms of planned development. They are compromising on the state's autonomy. Everything we need to approval from the finance from the state, from the Planning Commission, and the role of the Finance Commission was more for the non-developmental activities, taxation, net distribution of taxes. Major funds were with the Planning Commission. So that becomes a frictious point, and there were also demands to reform the planned development as it affected the center-state relations as well. So with the 7th 5-year plan and the opening of the Indian economy, the planned development moved towards from centralized planning to more of an indicative planning. Also the 73rd and the 74th Amendment Act, they constituted the district planning committees and metro planning committees to carry out bottom-up decentralized development planning at the local level. And also many states were also that time also constituted state planning boards to carry out planned development. But what you will constitute and do when you don't have financial powers? Though in on paper they adopted indicative planning, but in reality it remained centralized planning. So that became more problem, though it's more of a frictious point, and everyone was demanding abolish this Planning Commission, especially regional parties. It's more of a super parliament, what not they were talking. And also the number of centrally sponsored schemes also increased drastically. Centrally sponsored schemes are those schemes which are formulated by the central government, even in the subjects mentioned in the state list and union list. So they formulate those centrally sponsored schemes for planned development, that is health, education, etc. For it, for the first year they have 60-40 share. In the backward state they have 90-10 share, that is 60% funds will be given by the central government, 40% will be by the state, and gradually it becomes 100% by the state. So that also becomes a major friction point between the central and state relations. So the gradually then evolution further happened to then in when the Modi government 1 came to power, Niti Planning Commission was abolished and Niti Aayog was constituted. Niti Aayog had an agenda to promote bottom-up planning, and centralized planning was totally abolished. But what happened then? All the financial powers were given to the Ministry of Finance. Planning Commission powers of financial allocation was given to Ministry of Finance. At least in Planning Commission the state had a say. National Development Council, they can talk here, but here Ministry of Finance will decide where to allocate funds. But at the same time you write the other side, even the Finance Commission has started to give funds for development in the health education sector, and how it gradually increased from 32% to 42%, now 41%. So funds were also increased, and the center also gradually reduced the centrally sponsored schemes, and that becomes less frictious point. But planned development still has been broken down into fragments, as you have Niti Aayog does not do centralized planning, promotes bottom-up planning, but district planning committees and metropolitan committees and state planning boards are dysfunctional. So where is planning now? So it's all gone to the ministries, etc., doing those planning. So that is how you evolution you write all these aspects. Now how the recent reforms? What are the recent reforms? Also here you can write how the growth of cesses and surcharges have affected the center state relation. This also become a friction point. Swachh Bharat cess etc. was taken to carry out development, plant development, but they are not shared with the state government, cesses and surcharges. That it also becomes a point of friction. GST compensation cess also. So these all aspects you write. Then you write the what are the impact of the reforms it talks about. So reforms were taken, whatever. So GST council came into being, Niti Aayog, then Finance Commission. So these are the reforms we were taken, GST council etc. That all it took away the indirect taxation power of the states. Also it took away the indirect taxation powers of the local bodies. Okay, and Niti Aayog, we talked about it, that you write how planning, it promotes bottom up planning, but there is no integration of bottom up planning because of non-existence of those bodies, DPCS, state public state planning boards etc. and finance commission, how the role of the finance commission is also gone down, because this also plays a role in distribution of net proceed of indirect taxes. So what is the relationship between them? So there is problem of relationship between these three. What is the definition? That's why economics Kelkar talks about that GST council should also give some funds to the local bodies, as it has taken away the indirect taxation powers of the local bodies. Some funds should be given to local bodies, and further he says Niti Aayog too should have some fund allocation powers, development for the planned developmental funds, because all the fund allocation power is now with the Ministry of Finance, and state do not have a necessary say with the Ministry of Finance. Here at least there is a regional council, governing council where states are represented, at least their inputs will be taken. And yes, planning this role has been diminished. So what is the relationship between this? These are the impact of the new reforms, and also GST 2.0. GST 2.0 reduce the number of slabs, so it will reduce the revenue also, which will be going to the government and gradually to the states. GST council will distribute this revenue to less revenue for the states. Now who is going to compensate the states? So many states, South Indian states, were talking about the compensation. You brought in GST 2.0, there will be a revenue loss for us. So what about their compensation? So these are the new aspects, new issues which are coming. You can write what the economist Kelkar has talked about, define this relationship etc., how GST etc. to local bodies as well. So this all aspects you can write this answer. Yes, this question also has a contemporary connotation rooted in the recent reforms. So current affairs important. So 15 is done. Let's take 16. So poverty question from different angles they keep on asking. So inequality in the ownership of pattern of resources is one of the major causes of poverty. Discuss in context of paradox of poverty. So for that you should know what is paradox of poverty. At least use a common sense, even if you know what is a paradox. When that is two opposite things exist together, that is a paradox. Okay, so paradox of poverty. What is poverty? On one side there is prosperity and one side there is poverty. That is a paradox. Here also hints are given. Inequality. So inequality, India is booming with so many millionaires, billionaires. Even the top 10 billionaires of the country you can find Indians, or top 50, so many Indians, but at the same time there are people who are dependent on the Pradhan Mantri Garib Kalyan Yojana. One side there is flourishing metro cities, and one side there is rural areas with abject poverty. One side you have states like Punjab, Haryana, Maharashtra, Tamil Nadu, very high per capita, and one side you have states like Bihar having per capita even less than African countries. This is the inequality. This is the paradox of poverty. So, introduction you can write poverty is about deprivation of resources, etc., and it has many aspects. It has many reasons like unavailability of resources, education, health, but inequality or ownership is one of the causes of poverty. Then you write inequality of resources, then you explain paradox of poverty. That is, paradox of poverty means on one side there is prosperity and the other side there is poverty. So, those aspects you write, billionaires, etc., and you can write the write those human development index also, how one side India is the fourth largest growing economy and ranks 131 or 132 out of 193 in the human development index, lower than some of the South Asian neighbors, Sri Lanka, even Bhutan are ranks higher than us. So, that is a paradox of poverty, and you write inequality over resources is one of the major, that land resources. Education capital, yes, access to credit will also come here. Health, all those aspects you write, how inequality ownership pattern, how how there is inequality. There is one side you have this prosperous region, agriculture region of Punjab, Haryana, and you have landless ravers. That is, questions on the land reforms initiatives also been taken. Also, as per estimate, how much 60-70% of the people own about so much of land, about 80-40% of land, some figures are there. Also, how top 1% of the top 10% of the India's rich has control over 77% of the resources. Education also has, certain regions have good engineering, medical colleges, some regions lack good education system. Then then you write about access to capital, where the billionaires, etc., have access to all kinds of capital. They take loans and run away from the country, and the poor entrepreneur, etc., poor people don't get access to credit. So, that is inequality over access to resources. And you write health, etc., also you can connect with the health, poverty, malnutrition, etc. That trap, people remain trapped in that cycle, and they remain unequal and not able to access to resources. So, also paradox of poverty. Then one region, the regions are highly mineral rich, the eastern part of the India, Jharkhand, Bihar, etc., but they are also one of the poorest regions of our country, having per capita income lower than African countries as well. And one side we have per capita income of some states matching to that, even some cities matching to that of even some developed regions. On one side we have 100% literacy, etc., in Kerala, and one side we have very low literacy in some parts of the country. That is how inequality and paradox of poverty, that is to carrying out sustainable inclusive development, equitable development. Even government has taken schemes such as Pradhan Mantri Jan Kalyan Yojana and Jan Dhan Yojana to improve access to credit, land reforms, etc., are much needed. Land leasing, etc., can help reduce this inequality and bring about more of an inclusive and sustainable development. So, that aspects you can, and also can connect with the sustainable development goals, poverty, equality, and even the constitution talks about remote equality is one of the DPSPs. So, those aspects you can write. The simple question, not much challenge to write. yes, some content can be taken from the planned center state financial relation plan development for this question. In the contemporary development, models, decision making and problem solving responsibilities are not located at the source of information in execution defeating the various objectives of development. Critically evaluate. So, introduction, right? What is development? Development is a positive transformation from the past. Development can be in the form of economic, social and political development as well. But traditionally the contemporary models is more of a top down development, that is top down development where schemes etc. is formulated at the top level, and the bottom level agencies are more of an implementing agencies. They do not participate in the development process. What is MG Narega? MG Narega social audit is there. MG Narega has been formulated at the top level. You just go and implement at the local level, and local level Gram Panchayat role is what? Identification of beneficiaries etc. and social auditing. Do they participate in formulating of the scheme itself? So it's more of a top down development. Even one can say that reforms which have been implemented as a part of the global governance, it's also top down. The reforms come from the global bodies, United Nations, World Bank, IMF, and the people and the lower bottom up people remains more of an implementing agencies. So it's more of a top down, and it defeats the very purpose of the development as that. Purpose of the development is what? Empowering people, that people able to take decisions for themselves, people becoming capable, that is a capability approach, people having the choice to take decisions, they are not depending on the government. That is the major objective of the development. Amartya Sen's capability approach, or what we call it, putting the last man first, principle of subsidiarity of Mahatma Gandhi. There should be bottom up development, but top down development happens, leakages etc. Then the people remain depending on the government itself. The government becomes my bap for everything. They are totally dependent on the government rather than developing themselves. So, but it's saying critically examining, but you have to also write that top down development cannot be totally negated, as people may lack the requisite capabilities to develop themselves. Without health, education etc., how will they will develop themselves? So yes, you can write the development should be a mix of top down and bottom up, like what Niti Aayog visualizes, a bottom up development, and with Niti Aayog plus social justice, that is what is the mix of top down or bottom up. Or you can also open up the angles of Gujarat model of development, how it's more of a top down, that private sector will play a role in development. And one you can write about the empowerment development model of Kerala development model, focus on health and education, make people capable, and it's more of bottom up development. So different areas, different societies, different types of development may work. Sometimes in bottom up, somewhere top down, and somewhere mix of both. That is what the Telangana CM talks about, the Telangana model of development: governance, social justice, and development by the private sector. Also there will be governance, that is people will also participate. Social justice, that is welfare also. So this is how development can be defeating the objectives etc. So this you have to critically evaluate. So in the end you can justify different societies may require different types of development, not necessarily the contemporary models are totally irrelevant. But also give more space to those negative aspects of top down, bureaucratic centralization, leakages etc., corruption, even MG Narega, how the corruption is happening despite the digital aspects. The top down model also incorporate technocratic approach where Aadhaar authentication is required, people are using their passport photographs etc., already photographs, taking photos from mobile phones to authenticate, and thereby corruption happens. So that's why top down development fails in that way. So for to have a bottom up development in true sense, you should empower the local bodies to carry out those bottom up development. Otherwise, in most of the cases, top down development models, the contemporary models may not be able to get the requisite results for development. Okay, so these aspects you can write. Governance question. Okay, so National Commission for Protection of Child Rights has to address the challenges faced by the children in the digital era. Examine the existing policies and suggest measures Commission can initiate to tackle the issue. So, National Commission, many times they were asking National Commission for Women, etc. Now this time child rights in context of the digital issues. So right in the introduction, National Commission for Child Rights was constituted as a part of the Commission of the Child Rights Act 2005. It has the mandate to monitor the various laws, etc. Regarding child rights. It has also power of a civil code. It can issue summons, etc. And it's an advisory body. It advises the governments, central government, state government, and even regarding child rights. So these aspects you can write briefly. So then you write what are the digital challenges faced by the children in the digital era. So what are the challenges? So challenges can be digital era trolling of children, screen addiction, access to explicit content, adult content, then video games addiction, then trolling, screen addiction, video games as addiction. Yes, trolling digital era. You must have also the KBC issue had happened, how that child was trolled on social media. What about the impact of that trauma? This commission has a mandate over some rehabilitation of children who are trolled, how to consult them, etc. Screen addiction, yes, very real screen addiction is there among children. Real addiction, social media publicity, what should be the age to come on social media. Screen addiction on one hand, there is digital India, digital education, then the digital education can also get transformed into screen addiction. How you stop the children who's watching videos for education purposes and then switches to reels, then that will result in screen addiction. Addiction by video games, it's considered as a medical issue also by the WHO. Screen addiction, video games addiction. Yes, many children are very much addicted to video games. Access to adult content, how to restrict access to adult content, whether the website, etc. has the filter to ensure the children do not access adult content. Also there is a recruitment by fundamentalists of children. How about brainwashing, etc. How to stop that online. These are the all aspects. Also the issues of AI, fake videos, etc. are generated. Recently I have read in the paper how a fake video of a child and his sister was circulated, obscene video, then generated by AI, and that child committed suicide. So what about that? What about restrictions? So National Commission for the Protection of Child Rights deals with all these digital aspects in bits and pieces. such as the POCSO Act gives powers to this NCPC for about child exploitation, child abuse. The IT Act also has given some powers to this agency to stop to remove those child abuse etc. videos. And then even the DPDP Act talks about that requires parental consent to process the children's information online. But there is no specific digital aspects which this agency deals with. Shouldn't there be some digital vertical that specifically focuses on the digital aspects of the children, digital challenges thrown on children? Shouldn't there be special you can say a monitoring agency within this regarding the digital challenges, like, or does it have an age appropriate code etc. as in UK? In the United Kingdom, they have formulated age appropriate guidelines which are given to all social media, that at certain age this should be the appropriate appropriate forum they can access. So what should be the age to access social media? Should be 16, 18 or should be 14? And how to ensure that those guidelines are followed? Then you can say there is facial recognition, but facial recognition can lead to violation of privacy as well. Should there be a mechanism where if some adult content etc. the reels etc. they are watching, then there should be some restrictions that you send an OTP. Suppose you take your parents' phone and you use for any browsing etc. So rather than facial recognition, if you can have there's some mechanism that it will send OTP to that mobile and you adult only can enter those OTP etc. So those all mechanisms can be there. So that's why there should be some digital vertically within the NPC monitoring the children behavior that can ensure the space safe digital space for children. Also, what about video game addiction? Does NPC has any mandate regarding it? It has only monitoring etc. monitoring reviews, sumo to action, that is civil court. There is no specific digital aspects in the Commission for Protection of Child Rights, that body. So they did also expertise should also be there in that body, but digital expertise. In South Korea, there are also video games. Cinderella law, some Cinderella law is there that restricts usage of video games for children. And also there has some time frame, even at that time frame only children can access some digital devices, not the whole night etc. That will affect the sleep cycle and affect their growth. Even they have video games rehabilitation centers. So these all aspects should be incorporated in the commission. So this all aspects can address the issues faced by children in the digital era. Yes, you must be seen that trolling of that KBC child, how badly it was trolled after that, and why that kind of behavior he exhibited, talking rudely to that to Amitabh Bachchan, where we already have a social morality of respecting our elders. So what about that parenting? Was it the influence of digital era, nuclear parenting, that digital aspects that you give up iPad or phone, the child keeps on playing? What about socializing with other children? What about socializing in offline space? What about going into parks, gardens and interacting with other children? So these are also challenges which a digital age is throwing to the upbringing of children. Rise of nuclear family, urban families. So these all aspects needs to be incorporated by NPC, and one way can be a specific digital department or vertical, you can say, in the commission itself, that will deal with all these challenges on time to time basis. Yes, AI will be AI can throw all kinds of different challenges to children. Those aspects also they should incorporate, and you incorporate your answer as well. Okay, so let's move further. IR questions, let's take those IR questions. 2 questions are there as 10 markers. Question number 9 and 10. India-Africa Digital Partnership is achieving mutual respect, co-development and long-term institutional partnership. Yes, important to read newspapers. This statement has directly plucked from an editorial of the Hindu. So, this exact statement and the whole editorial was talking about this only, mutual respect and India-Africa digital partnership. So, yes, in the introduction you can write the India-Africa partnership, India-Africa digital partnership is a partnership of is a continuation of the India's India-Africa partnership is a digital partnership, can be a cohesive partnership as it overlaps with the the Africa digital transformation 2020-2030, that is they have their own transformation plan or policy, Africa digital transformation. And with Digital India, where India has built a substantial digital public infrastructure based on public good and it's open source. So, there can be a cohesive partnership between India and Africa digital partnership, and it is based on the pillars of, then you write mutual respect, A, mutual respect, B, co-development, and C, long-term institutional partnership. So, as then you write, make these three headings and write about these three, write on these three headings. Mutual respect, that India's digital partnership is more of a, with Africa is more of a demand driven rather than surveillance. That is, we have an we have built a digital public platform as a public good, and it's an open and it's a open we can say open policy, open source, not policy, it's an open source. And demand driven is the how it is demand driven. That is, we do not ask everyone to take the entire package of digital public infrastructure. You take whatever you want, that is respecting each country, mutual respect. Demand driven will be you take everything, you take Aadhaar, take UPI, you take our Jam Trinity, etc. So, that is why based on need to basis, demand driven. So, we have partnered with Nambia for to develop UPI like architecture in the Nambia. Also, Togo has in collaboration with IIT Bombay want to develop a national identity system similar to Aadhaar. So, it is more of a demand driven, and it is not surveillance that only Chinese engineers will be appointed, etc. So, it is also more of co-development, that is we are partnering also, India also partners with the African countries to develop this. So, India co-development, yes, Zanzibar, in Zanzibar, with Zanzibar we the IIT Madras has signed an MOU to build have opened their offshore campus in Zanzibar, where they will be teaching AI and data science courses. So, it is a co-development. So, we will capacity building of the human resource of Africa as well. Not that only Chinese engineers, etc. will do all the aspects and they will keep all the technicalities with them. So, that way it is more of a co-development MOU. And also the Indian private sector will be providing scholarship to these people who will be enrolling for courses of AI and data sciences. Also, India also provides long term credit for their digital aspect digital Africa partnership, digital Africa transformation initiative. So, it is more often a co-development. Also, long term this all it becomes also long term itself, that we have building universities, long term credit, capacity building. So, based on these three pillars, the India Africa partnership is there. It's more of an demand driven, not surveillance driven, capacity building, not imposition of the workforce on African nation. So, and also the African countries have more similarity of India as well. There are different African countries, so India also has experience with having those digital infrastructure tailored to the all regional languages. So different languages also they can have, depending on which African country those models are taken of digital public infrastructure. Also there is also digital literacy issue is also in India, so is in Africa, a rural urban divide. So problems are more or less similar. So it's more of a cohesive and national partnership, and given the shared history of shared colonial history and the shared colonial history, India advocating for freedom of the African nation during that time, and India digital partnership, Africa is more of a continuation of that partnership and more of South-South collaboration between India and the African countries. So that way you can write this aspects include all these micro initiatives as well. So directly picked from the Hindu article on this. So let's move to the next question. With the waning of globalization, post Cold War or world is becoming a site of sovereign nationalism. Elucidate. So waning of globalization. So what are the developments which points towards the waning of globalization? So waning of globalization did not happen all of a sudden. There were certain developments. If you want, right, 2008 global crisis, financial crisis, then Brexit, then COVID, and Mr. Donald Trump. Tariff wars. So these all aspects led to the waning of globalization. Some even commented that globalization is on the reversal. That is, globalization was supposed to move towards a global village. That is to form a borderless world. But these all aspects points to the waning of the globalization, of global crisis, Brexit, COVID, the tariff wars, the current tariff wars has resulted into post-World War world. The post-World War world again representing the Cold War era. The world is divided into blocks: the East bloc and the West bloc. So and it's more of a reassertion of the Treaty of Westphalia, where borders are to be protected. So this is what is happening with the waning of globalization, becoming a site of sovereign nationalism. So the globalization, the Cold War came to an end with the fall of the Berlin Wall, and the US president now wants to build a wall over Mexico-US wall. So it's more of a sovereign nationalism, no free movement of the people, deportation of migrants. Then the tariff wars of the West. The tariff wars, we put some question mark of the global institution which came to existence for global governance. The WTO has become irrelevant. So asserting sovereign nationalism, you talk with us one to one, not through that WTO organization. Even the withdrawal of US from many United Nations organization, UNESCO, United Nations, then also that Human Rights Commission, US withdrawal. So asserting sovereign nationalism. Even you say that this is the death of multilateralism as well. Post World War era, Cold War era, and then you can connect with the Russia-Ukraine war as well. Why Russia-Ukraine war happened? Because it was more for assertion of the nationalism, sovereign nationalism of Russia. Ukraine was moving towards the west and joining NATO, but he wants to Putin wanted that to remain in the Russian fold. Sovereign nationalism. Even the cultural clash which is happening in the west, anti-immigrant sentiment in the west, also in Australia against immigration, that is assertion of sovereign nationalism. So that is globalization is waning. So this is what you can write a sovereign nationalism. Even in India, it talks about Atmanirbhar Bharat is Atmanirbhar Bharat, make in India. Also, and so there is make in China policy also in China. It is part of their 5-year plan. And in United States, the president talks about MAGA, make America great again, asserting of sovereign nationalism, make Europe great again. This is all our sovereign nationalism, but globalization is also said to be like an herd. Whoever comes in between will be destroyed. So globalization will continue. Also, most likely in the New York City, that mayor will be elected who has policies totally against sovereign nationalism. What is his name? Mamdani. Mr. Mamdani is most likely to be elected. So it's more of a continuation of the globalization. That debate is further you can talk about. That is not much you can write there, and it was not in news when the paper was framed. This is what on these lines you have to write the answer to this. Last 2 questions are remaining. Yes, 19 and 20. See, this is a bit tricky question. Energy security constitutes a dominant kingpin of India's foreign policy. And is linked with India's overarching influence in the Middle Eastern sectors. How would you integrate energy security with India's foreign policy trajectories in the coming years? So 1, 2, 3. See, you have to, in a way the question is saying that the foreign policy in India is determined by its energy security. On that lines you have to write. Not that you have to analyze only India and that West Asian countries, Middle Eastern countries. You have to write that this Middle Eastern countries relation with the Middle Eastern countries is foreign policy is this energy security remains the kingpin. So that way you have to write. And in the near future, how energy this foreign policy will incorporate the new aspects of the energy security. Okay. So in the introduction you can write that India for its energy needs is dependent on the India for majority of the energy needs, that is 80% of its crude oil and around 50% of its natural gas is dependent upon the other countries. That India has very few sources, domestic few sources of energy. So they are dependent upon this. Out of this, 2/3 of India's energy needs come from the Middle Eastern countries. So if you want, you can draw this map and show where what all we import. So Saudi Arabia, etc. you can write. Okay. So So, as India is totally dependent on imports for its energy needs, any disruption in the India's relation with any disruption within the West Asia can negatively affect India's development and economy. Without energy, what one country can do? It will become totally stalled. So, India's foreign policy is framed in such a way, keeping in mind the energy security in India, energy security of our country. So, you take analyze then India's foreign policy with respect to Middle East. So, Middle East is full of contradictions, that countries are divided among themselves. So, Iran and Saudi, Iran bloc, Saudi bloc, then we have Israel, Palestine, and also US influence, Russia and China's influence. So, you have to balance all these players, so to maintain energy security in India. So, India has a strategic independent foreign policy which each of the players. India does not totally side with Saudi Arabia or totally isolate Iran. So, India is the largest importer of oil, crude oil from Saudi Arabia is the largest exporter of oil to crude oil to India from the from the Middle Eastern region. Similarly, India has also strategic relations with Iran, where India takes about the development of the Chabahar port, and also Saudi Arabia sought to develop a refinery in collaboration with Aramco in Ratnagiri. So, that is, we balance this relation between both of them, not that we totally side with the Saudi Arabia or totally side with Iran. Similarly, with Israel and Palestine, India maintains good relation with Israel, especially in the keeping in mind, especially in the new and renewable energy sector, and as well as talks about Palestinians' autonomy to Palestine. So, India does not take sides in the Gaza war, etc. So, that way, how with foreign policy it seeks to balance the energy security. Further, Iran, this Middle East, the West Asia and Middle East can act as a crucial link in the international north-south corridor, where a connectivity to the Central Asia, which are the also good producers of natural gas. Also, India imports LNG from Qatar. So, all this, because of this foreign policy remains dominant in the energy security sphere. Further, India has a BRICS Energy Security Forum as well, and also some of the Middle East countries are also now members of the BRICS. Yes, Iran and UAE. So, here you bring them so that you remain their relations remain good with them. You can talk about energy with them. Our energy security remains intact. Further, India is a dialogue partner with Gulf cooperation countries. India is also associate member with International Energy Agency. So, India maintains its foreign policy remains as a keeping navigating around the energy security needs of the country. So, in the near future, with the world with the waning of globalization, the world is becoming less predictable, especially what the Russia-Ukraine war, and then the Israel-Gaza conflict which is going on, and there was also bombing of Iran by Israel. So, if everything comes to stall, what about our energy security? So, that is why India has been diversifying its energy security needs, even from some of the African countries, as well as the shale gas reserves tying with the US, and also now with the evolution of technology, as conventional sources are gradually replaced by the renewable energy sources, then India needs the foreign policy, keeping in mind this renewable energy, because we do not have the requisite, what you say, we do not have the the raw materials etc. to harness this renewable energy, the rare earth materials, the silicons etc. which you require for the solar etc. So, for that we need to diversify towards China etc. to meet those needs. So, the future energy should be the future energy aspects, you should write upon those renewable energies, diversifying from the existing, because Middle East, Western Asia anytime can becomes tumultuous etc. remains non-predictable region in the prolonged Russia-Ukraine war, and also we have been taking oil etc. from Russia at a discounted rate. Now the Trump tariff and those negotiation again going on, and we need to further diversify etc. So, these are the future energy needs, as India is an energy hungry nation, and also with industry 4.0, those technologies coming, which are very energy intensive, will require more energy. So, more diversification based on, we need to energy based on accessibility, affordability and availability. So, this all you can write, these aspects you can incorporate. So, let us move to the last question. The reform process in the United States remain unresolved because of the delicate imbalance of East and West, entanglements of the USA versus Russia-China alliance. Examine and critically evaluate the East-West policy confrontations with regards. So, yes. So, basically the question is saying that reform process has been stalled in United Nations because United Nations is divided among East and West, and entanglements, that is Russia and these two blocks remain constantly at friction. So, you have to you have to examine this East-West policy confrontation. So, basically more likely it talks about the UN Security Council reforms. So, that reforms remain stalled. It is still representing the Cold War era, post World War II era dynamics. The 5 players remain in power: Russia, US, China, the French and United Kingdom. So, basically in the introduction you can write the United Nations represent the post World War II era, which seeks and is based on the pillars of sovereign equality, prosperity and collective security. So, but the reform process in the United Nations, particularly the United Security Council, remained unresolved, as you can write those 5 players dominate. There is no representation of the global south, no representation of Africa, does not reflect the today's world order, but there are emerging countries like India etc. which do not find its place in the permanent membership, and also the reform process is divided among the East and West confrontation. So, West wants liberal order, the East wants sovereign the East wants to respect their sovereignty. They want liberal democratic, human rights, democratic values, same democratic values throughout the world. But they say that our countries are different, they are not totally capitalist etc. So, it is more of an US or more of after the end of the Cold War, US become the sole player. So, they talk the East West is more for a unipolar world and East is for multipolar world. So, that are the more differences that keeps on coming, and this is reflected in the real world order as well. The Russia-Ukraine war happens, it's more war, it is war, it is East versus the West. The Ukraine was drifting towards the West to join NATO, and Russia did not want it, so the war is going on. In the East-West confrontation it remains, and so whatever veto power they have been used for their own interests. So where the USA keeps on blocking the resolutions on Israel, and the Russia etc. China had kept on blocking the resolutions which are against their eastern interests, against Ukraine etc. or for Ukraine etc. So that remains a point of confrontation, and also it further reflects the confrontation that USA is selective about the reform, who should be in the P5, whether it should be expanded or no. It has throwing mixed signals regarding India. So as China, Russia is more for yes, it sometimes say yes, India should be part of the P5, enlarged P5, and within the General Assembly also there is another group of countries united for consensus that do not want the expansion of the P5. The countries like obviously it will be Pakistan. Pakistan doesn't want India to be a part of the P5. The P5 members, enjoy the veto power, and so and similarly South Korea doesn't want Japan to be the part of P5. Italy is also opposing the Germany. So there is also lack of consensus regarding the reforms, and this also reflects the East-West divide in the United Nations. And General Assembly the General Assembly is the assembly of all the countries, and the veto powers is with the P5. So assembly also becomes fructuous. The assembly passes a resolution and then it may be vetoed by the P5. On one hand, you can say the United Nations on one hand the United States enjoys the veto power in the United Nations UNSC, and on the other hand United Nations exits from some of the UN bodies, UNESCO, UNHRC. So it itself is a paradox, reflects East-West confrontations. So yes, gradually reforms should be happened. There should be appropriate representation of the countries in the P5. India, emerging countries should have a representation. So there is no representation in the global south. Which countries of the global south has a no country have a representation in the P5. No African country, no South American country, no South Asian country. So it's more of a outdated now, that it represents that time of era, but the era has changed, and also the veto should be minimized. The use of veto, it can be used only for humanitarian purpose, not that it get totally divided between East and West. So it's more of this way you can write these all aspects. Yes, hopefully all questions are done. Yes, see polity questions were indeed challenging. You should be able to identify what the question is asking. You should not rush to write whatever comes to your mind, especially when questions are tricky, as in the polity question. The constitutional morality, judicial independence, accountability were challenging. But if you break it down, how we break it down, then it could be easy to write. See, content, everything you have is just about critical thinking and generating that content in the exam pressure situation. That will come only from practice. When you practice all these aspects beforehand, then you can write those. We have been incorporating this type of questions in our test series. Many people have benefited from that. If you want, you can check our past year papers of our test series or this year's papers. Many aspects, constitutional morality, etc., judiciary, we had incorporated. Even J&K, we were expecting that question will come, because elections happen, and obviously there was issue regarding those 5 nominated members as well. So that was also on the expected lines. So was RPA, collegium system, yes, judiciary, all questions were on the expected line, because a lot of things were happening in the judiciary. And yes, so if you prepare well, etc., you can write this paper in a much better way than in a relative sense. And also the pardoning powers, etc., preemptive pardons were also in news. So if you go December 2024, etc., that time this preemptive pardon, because Joe Biden, that president, had given preemptive pardon to his son Hunter Biden. That was on news all over the social media, and newspapers also covered it holistically. Also, Attorney General question, the challenge was opening up the sound governance aspect. So that many people may have not, some would have, then yes, of course you will get the marks, because it clearly, concisely talks about you have to discuss this in this regard. Okay. So this way, so prepare well, etc. Yes, current affairs important for GS2, so are for GS3, but we are specific to GS2. Yes, this December, November to February, March, they ask most of the current affairs questions from that period in the mains examination. So that period is important. Okay, then hope this session was helpful for you, and like always, happy learning.